Last week was Valentine's Day, and today I want to tell you a story about a Valentine's Day that was not so rosy or romantic for two friends who got involved with a business transaction. In the case of Blocker versus Josephson, which was heard on 14 February 2023, that's last week, Valentine's Day, Mr. Blocker loaned money, a substantial amount of 2.5 million rand, from his friend in 2015. They entered into various acknowledgement of debt agreements, wherein the terms of the repayment of the amounts loaned were set out. After Mr. Blocker already paid back over 3 million rand, Mr. Josephson wanted to claim a further 1.5 million rand from his friend by firstly private arbitration, and thereafter the matter proceeded to court. Although his claim initially succeeded, it was dismissed by the full bench at the Western Cape High Court on Valentine's Day because the initial AODs were unlawful credit agreements. AODs are acknowledgements of debt. What is an unlawful credit agreement? Well, an unlawful credit agreement is one where, in this particular instance, the transaction was at an arm's length between two natural persons over the amount of 500,000 rand, and the National Credit Act requires that in such an instance, the credit provider, which was Mr. Josephson, who provided the loan, had to have been a registered credit provider with the National Credit Regulator, or the NCA. Interestingly, we should note that currently any credit agreement, regardless of its amount, will be subject to the provisions of the NCA, that's the National Credit Act, because there is no longer a requirement for a loan to be at a minimum of an amount of 500,000 rand. In any event, Mr. Josephson proceeded to rely on this unlawful agreement to reclaim his monies from Mr. Blocker. The court would have none of this because laws are there to be obeyed. Judge Shea wrote in his judgment, to which Judges Legrandsie and Gamel concurred, that the objectives of the NCA were clear. These are, and I quote from this judgment, to promote and advance the social and economic welfare of South Africans in order to achieve a fair, transparent, competitive, sustainable, responsible, efficient, effective, and accessible credit market and industry, and to protect consumers. The judge goes on to confirm that these are important and laudable aims. The bottom line of this judgment is that, should you wish to advance a loan to a friend, contrary to the requirements of the NCA, you will do so at your peril. If your friend doesn't abide by the agreement, the courts will not aid you to enforce such an unlawful agreement. So what are the important items to look out for if you find yourself in the position of Mr. Josephson? Perhaps you would like to help a friend in need, just like him. I will talk about 5 things that you need to remember when loaning money to someone. As a favor, basically. Obviously, if you are going to be in the business of loaning money or you're a registered credit provider, then this is not for you. So these 5 things are, number 1, natural person versus juristic person. The National Credit Act applies to all natural persons and some juristic persons. As a rule of thumb, if you're entering into a transaction with a natural person, you should be more cautious. Juristic persons with an asset value or an annual turnover exceeding 1 million rand are generally, not always, excluded from the National Credit Act, specifically for transactions exceeding 250,000 rand. However, I would advise you to look for legal advice on this specific aspect to be sure that your risks are mitigated in the event of a transaction with either a natural person or a juristic person if you are not a registered credit provider with the NCR. The second thing is, I've mentioned something about an arm's length transaction earlier. So the National Credit Act applies only to transactions occurring at an arm's length. The Act defined what is included or excluded from an arm's length transaction And generally, if you are providing a loan to a friend, this would be considered a transaction at arm's length. Transactions with family members may be considered excluded from the application of the National Credit Act, but only if these family members are dependent on you. Importantly, it should be noted that the NCA applies even if the credit provider, the person who actually extends the loan, doesn't reside in South Africa. So if you are outside of South Africa and you wish to loan money to somebody inside South Africa, that will also have repercussions for you. The third one, let's talk about a credit agreement. A credit agreement can broadly be defined as an agreement entered into or a transaction. It doesn't necessarily have to be something that is written down between a credit provider and a consumer in which the credit provider supplies goods or services or lends money to consumers. There are many examples of specific types of credit agreements in the NCA, and you should check whether your transaction constitutes a credit agreement just to be sure. Number 4, the NCA requirements for credit agreements. Amongst others, the credit provider is obliged to perform a credit check on the consumer prior to extending the credit. This is to ensure that a consumer doesn't overextend themselves by obtaining more credit than they can afford. Additionally, before a credit agreement is entered into, the credit provider must provide the consumer with a pre-agreement statement and quotation. So if you're going to make a loan to a friend, this may not apply because you may not be a registered credit provider. But if you're the one obtaining a loan, you should also know your rights and demand that the credit provider complies with these requirements. So what is a pre-agreement statement? That is a document that details the terms and conditions of the credit agreement that the credit provider intends entering into with the consumer. And a quotation is a document which discloses the principal debt, the interest rate, the total amount payable under the agreement, the installments and all fees, charges, and interests. So basically the costs of credit. So watch out for that if you're the one obtaining a loan. Now, number 5, there are certain types of loans or products that are covered by the NCA. The Act specifies many agreements and transactions that could qualify as credit agreements, but it generally covers personal loans. So that would be the loan between two friends, for example, home loans, business loans, depending on the threshold values applicable to the consumer. So for example, the 250,000 Rand that I've explained to you is applicable for juristic persons. Overdrafts, credit cards, asset-based finance, installment sale agreements, and lease agreements. So there are quite a few things that are subject to the NCA and its provisions. So now that you know your basic obligations in terms of the NCA, be sure to insist on dealing only with registered credit providers. Or if you are considering advancing a loan to someone, make sure that you can enforce the agreement if there should be any problems, because the problems don't arrive when we're all friends. The problems arrive later when the money isn't there anymore, or something happens and the person that was supposed to pay you didn't pay you. So guys, I'm trying to make law more accessible for everybody. Please let me know what you thought about these tips and have a fantastic day.